Hello friends, welcome to IAS at Speed of Light, and we are starting with part 4 of Indian Polity Conceptual Lectures. Before we move to the main lecture, there have been many queries from the students regarding how to approach state civil services examination. So let me briefly discuss how you need to approach a state civil services examinations. If we broadly divide, there are three different aspects of state civil services. The first one is related with state informations. Second one, it is the same as UPSC. And the last one is a static GA questions. Okay, so state informations, it plays a very important role in state civil service examinations. For example, like what we have done for India, we have given different images to different states, the known images to different states and union territories. Similar way, what you have to do is you have to list down all the districts of that state, and then first step is you have to give a known picture which is there in your mind for all those districts of that state. Let me take an example here. Suppose if you are preparing for MPPSC. So there are 51 districts in MP. You have to list down all 51 states. Let me take an example. I'll take Indore, which is one of the districts, Bhopal, Sagar, and Bhind. These are four districts of MP. Now what you have to do is, first thing is you have to give picture to each one of them. For Indore, it becomes Indore or Indore Stadium. Bhopal is infamous for the Bhopal gas tragedy. So for Bhopal, it becomes gas to me, Bhopal gas tragedy. So gas will be the picture for Bhopal. Sagar is a Hindi word for ocean. And Bhind, for me, it becomes bhindi, which is a vegetable, lady's finger. So bhindi. Now you have to remember the first Central University of MP was opened in which district? So answer will be Sagar. So now ocean, you have to link it with the university. Similarly, if you have to remember Bhind as the lowest sex ratio district of MP, then you have to relate bhindi, which is the vegetable, with lowest sex ratio. The biggest indoor stadium of MP is in Indore. So Indore becomes Indore Stadium. So that is how now you have to relate all the required information for those districts with the images. Like what we have done for India, same thing you have to repeat for that particular state. So that is how you are going to cover the state information. Then second portion is which is same as UPSC. For example, Indian polity, Indian history, Indian geography, economics. But the questions which are asked in state civil services, they're very straightforward and easy. So if you are following these lectures, if you are following the mnemonics, if you are following that reference books, what we have referred, there are all chances that you will score all 100% of the questions in this. The third portion is GK. There are some static GA questions which are asked in state services, like, for example, they will ask which is the largest freshwater lake of the world. Okay, so these sort of questions you have to prepare from a book, Lucent, Lucent General Knowledge. So this Lucent General Knowledge, if you cover, it will cover almost all the areas of the static GA part. And again, you have to follow the same memory techniques, same image picture memory techniques to cover that GK fast. And if you go this way, you will have a far better edge than the rest of the competitors. Okay. Another interesting thing to discuss here is suppose number of vacancies in a year of 500 for the state civil services. So they call around 2,500 students for mains, around 4 to 5 times, and the people who apply for prelims more than 4.5 lakhs. So if you see, the biggest hurdle is to clear prelims, and if you are clearing prelims, then in mains there are high chances that you will be a successful candidate and you will be in the merit list. And the questions which are asked in mains are also very straightforward. Okay. So this is how you have to approach state civil services, and if you get any problem and if you want further counseling for any particular state civil services, you can again call us or you can mail us your the queries. Now let's move to the main lecture of today. We are studying the part 3 of Indian Constitution, which is a fundamental right. Last time we have finished till article number 24, which is right against exploitation. Now we are starting with the new set of rights of part 3, which are right to freedom of religion. And we are starting with article number 25. You should read the article from PM Bakshi, page number 72. The reason for introducing this practice of reading yourself from PM Bakshi, it will induce confidence in you that okay, you are reading from the Constitution and you are getting the meaning of these articles, and it is not so difficult to interpret these articles. Right, so article number 25, it says freedom of conscience and free profession, practice and propagation of religion. Part 1, it says subject to public order, morality and health and to the other provisions of this part, all persons are equally entitled to freedom of conscience and right freely to profess, practice and propagate religions. So here if we see this particular article 25 part 1, it gives us four types of freedom regarding freedom of religion. The first one, they say freedom of conscience. Freedom of conscience, it means conscience means the freedom to listen to your conscience, freedom to listen to your inner self, and in what way you want to pray to God, in what way, in what creature you want to see your God as. So freedom of conscience is the first freedom. Second is right to freely profess. It means the declaration of your beliefs, okay, declaration of your faith in open public. So this is declaration of your faith. That is a fundamental right. Right to freely practice. What practice? The different rituals, the different various forms of worships which are there in a particular religion. So right to freely practice the rituals or the modes or ways of worship or ways of worship. Right to freely propagate the tenets, okay? Right to freely propagate what? Propagation of your ideas, of your religion, of your particular religion. Right to freely propagate the tenets of your religion. So these are the four things what this particular article talks about. Freedom of conscience, freedom to profess your religion, declaration of your religion, freely practice your religion, the different rituals which are there in your religion, and freely propagate the ideas of your religion. But another thing to discuss here is this right to freely propagate doesn't mean you can forcefully convert, okay, forcefully convert other person into your own religion. So right to freely propagate doesn't give the right to convert other person. Okay, so let's move to the second part of Article 25, which is nothing in this article shall affect the operation of any existing law or prevent the state from making any law. So it will not affect if any particular law is in operation, or it will not prevent the state to make a new law, regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. B. Providing for social welfare and reform or the throwing open of the Hindu religious institutions of a public character to all classes and sections of the Hindus. So it gives us two things. The state can restrict or regulate uh, the things associated with religious practices subject to public order, health and other provisions. B, it is saying a very interesting thing to provide for social welfare and reforms of Hindu institutions. Okay, it has been rooted in our culture from a long time that the people who are belonging to a particular caste who have got birth in a particular caste, they are not allowed to enter into the place of public worship. So, Constitution is saying to provide for the social welfare and reforms of these Hindu institutions and throw them open to all the classes of Hindus, irrespective of what is the caste of a person, irrespective of what is the race of the person. Okay. This particular article has two explanations also. Explanation 1, the wearing and carrying of kirpans shall be deemed to be included in the profession of Sikh religion. So they are saying in the Sikh religion, if a person is belonging to a Sikh religion, then carrying of kirpans is allowed to him because that is a part of his religion. Explanation 2, they're saying in subclause B of clause 2, okay, which was related to the reform and throwing open of Hindu religious institutions. Hindu shall be constructed as including a reference to persons professing the Sikh, Jaina or Buddhist religion. So this word Hindu, it includes these three others also, Sikhs, Jains and Buddhist. Okay. Now, if you read it again, part 1, which says all persons are equally entitled to freedom of conscience, etc. So, all persons, this means this is available to both citizens and foreigners. Okay. So, this right is available to both citizens and foreigners. Let's move to the article number 26. Which is freedom to manage religious affairs, page number 75 of PM Bakshi. Again, subject to public order, morality, and health, every religious denomination or any section thereof shall have the right. So, first thing, what you have to, how you will distinguish with article number 25, there we are talking about the individual freedom. Okay, individual, the freedom of religion to a particular individual, but here we are talking about a section of people, a complete religious denomination. Okay, so they have the right to establish and maintain institutions for religious and charitable purposes. Second, to manage its own affairs in matters of religion. C, to own and acquire movable and immovable property. So now this is an interesting article, article number 26 part C, which gives the right to property explicitly to the religious denominations, that they have the right to own and acquire movable or immovable property. Part D, it is to administer such property in accordance with law. So this right is very clear. And how it is different from Article 25? This particular right, right number 26, it protects the collective freedom of religion, while previous article was related to the individual rights. Okay, let's move to the article number 27, which is on page number 77, and it says freedom as to payment of taxes for promotion of any particular religion. So freedom as to payment of taxes, so we cannot be compelled to pay taxes for the promotion of any particular religion. So any particular religion we cannot be compelled to pay the taxes. But here another one thing to discuss is this tax is different from the fees. Okay, this provision prohibits only the levying of tax on common people for the promotion of a particular religion, while certain pilgrimage center, if you go, certain temples, if you go, they ask for a fee. So these fees are not covered in this particular article because these fees are meant to be for the promotion, for the development, and for the maintenance of those pilgrimage centers and temples or the masjids, etc. Let's move to the article number 28 now, and it says freedom as to attendance at religious instruction or religious worship in certain educational institutes. So this is clear. Freedom, nobody can compel us to attend the religious instructions or religious worship of a particular religion in a certain educational institute. Its first part, if we read, it says no religious instruction shall be provided in any educational institute only maintained out of state funds. So this, they are talking about institution which is wholly managed by state governments or by the government itself. So no religious instruction in institutions owned and operated by the government. Second part, if we read, nothing in clause 1, okay, the above clause, which talked about the institutions which are wholly managed by the state funds, shall apply to an educational institution which is administered by state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institutions. Now, this article is talking about those institutes which are opened by the state, but for the specific purpose to give those religious instructions. Okay. So this particular thing, law, it doesn't apply to these institutions which are actually open for that particular specific purpose only. Let's move to the part 3. It says, no person attending any educational institution recognized by the state or receiving aid out of state funds. So they're talking about the institutions which are recognized by the states, or either they're receiving aid from the state, shall be required to take part in any religious instruction that may be imparted in such institution, or to attend any religious workshop that may be conducted in such institutions or in any premises attached thereto, unless such person, or if such person is a minor, his guardian has given the consent to. So they're talking about the different set of institutions here which are either recognized or which are receiving the aids from the state. In these institutions, the students cannot be compelled. Okay, it will be on the voluntary basis that if these students want to participate in these religious instructions or worship, and if student is a minor, the consent of his guardian will be required. So this what Article 23 it talks about. Now, if we see this article is giving us information about four different type of institutions. The first institution, it is wholly maintained by state or owned by state. Second, owned by state but meant for religious instructions. Meant for religious instructions. And third, they're talking about those institutions which are recognized by state or receiving aid from the state. So this article said wholly maintained by state, no religious instructions. Second thing, it is allowed. Those who are open for religious instructions under the state. Third, recognized by state or receiving aid from the state, those institutions, it is on voluntary basis. Okay, so this is clear. Let's move to the next article, which is article number 29. And if we read this article, here we start with cultural and educational rights. We have finished right to freedom of religion, which was from article number 25 to 28. Let's go to the article number 29, protection of interests of minorities. Part A, it says any section of the citizens, mind the word any section of the citizens, residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. So they're talking about any section of the citizens. So this includes both majority and minority. This particular right, it is not talking about the minority of people. Any section, whether it's a majority or the minority, if they're having a distinct culture, if they're having a distinct language, they have all the right to protect the same. So right to conserve distinct language, script or culture, whether majority or minority. This also talks about both the religious and linguistic minorities. Okay. Let's go to the part 2. No citizen shall be denied admission into any educational institution maintained by the state or receiving out of state funds on grounds only of religion, race, caste, language, or any one of them. So here we see this is an individual right, and this is a group right. Now, another thing to discuss here is to conserve my language or to conserve my culture if I'm agitating, that also is a right. It's a fundamental right. That is an inferred right from Article 29(1). Right to agitate for protection of language or culture. So the politicians who give speeches during the elections regarding the protection of a particular language, that doesn't amount to the correct practices. Okay. Coming to the article number 39, which says right of minorities to establish and administer educational institutes. So they're talking about the minorities. They have the right to establish their educational institutions. Let's read part 1 of that. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Now, if you note the word, article number 21, it was saying the section of people. So we inferred it is applicable to both the majority or the minorities, but Article 30 is specifically related to the minorities. Okay, so all minorities they have the right to establish and administer educational institutions. Let's go to the Article 30, Part 1A, which is a very important article. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by a minority referred to in as Clause 1. Clause 1. The state shall ensure that amount fixed by or determined under such law for the acquisition of such property is such as it would not restrict or abrogate the right guaranteed under that clause. So we have seen right to property under Article 19, and Article 31 has been removed by the Constitution Amendment Act 44th. But here, for the minority institutions, if the state has to acquire minority institutions, the property of minority institutions, they are required to pay full compensation as per market price. So this is a very important article which still gives right to property or right against deprivation of property to the minority educational institutions. So this is a very important article and has to be remembered. And if we see the wordings of this article is very interesting. It is saying the amount which will be fixed by the state should not be such that so that it will restrict or abrogate the right guaranteed under that clause. So what it means to say is amount should not be so less that it will be negligible. The amount which government is going to pay for the acquisition of such property has to be competitive. Okay, so the full compensation has to pay as per the market price. Let's read the part 2 of Article 13. The state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. So no discrimination in granting aid to an educational institution managed by a minority. Okay, so this is all about the cultural and educational rights, article number 29 and article number 30. Let's move further, and we have seen article number 31. It was repealed by 44th Constitution Amendment Act, the right to property. Originally, this right to property was under the 19 Part 1 Subpart F and Article number 31, the right to freedom and the right to property. Article 19(1)(f), it guaranteed to all citizens the right to acquire, hold, or dispose of property, while Article number 31, it guaranteed to every person, whether citizen or non-citizens, right against the deprivation of his property. Okay, so these two articles were originally there. So it laid down the conditions to the state. If state has to acquire a property, there has to be two reasons for that. First one, it should be for the public purpose. Okay, and second is it should provide for the payment of compensation to the owner from where the state is acquiring the property. So obviously now the most controversial part was the compensation which has to be paid to the owner by the state. So this was the most controversial part. Now, what with this 44th Constitution Amendment Act did it removed these two articles. It removed these two articles and it placed right to property under Article 308A with the heading right to property. Now, still it remains a constitutional right, but it is outside of Part 3, so it is not a fundamental right. So let us see what are some of the implications of removing right to property from fundamental right. Now, it is not a basic structure of the Constitution and it can be amended by ordinary legislation. So this is one of the implications straightforward. And the aggrieved party cannot move to the Supreme Court directly for its violation, though it can move to the High Court under Article 226 for the violation of fundamental rights or constitutional rights. No guaranteed right for compensation. So here what they did is there is no guaranteed right for the compensation. But still there are certain articles which talks about the compensation for the acquisition of property by states. One article we have already seen, which is article number 30. In case of minority education institutions, if a state acquires that particular land, it has to pay a compensation, and it should be competitive. Second, which we are going to study, will be the article number 31A. In case of a personally cultivated land, if a state acquires that particular land, then it is bound to give compensation. So this is the present position of right to property in the Constitution. Let's move to article number 31A, B, and C, and these articles are known as the exceptions to fundamental right. Exceptions to fundamental right. So here government is trying to make certain laws. If they are in violation with fundamental rights, it has to be void. It can't be declared void by the courts. So article number 31A actually it says 5 categories of laws from contravention of fundamental rights under article 14 and under article 19, which is right to equality and right to freedom. So for these 5 categories, if a government makes any laws, these laws will not be considered as a contravention of the fundamental rights by the court. Only with regard to article number 14 and article number 19, and these are related to agriculture land reforms, agriculture land, industry and commerce. Right. Another important article under 31A, it is, if you can open page number 84 of PM Bakshi, the fourth para, it says, provided further that where any law makes any provision for the acquisition by the state of any estate, and where any land comprised therein is held by a person under his personal cultivation, it shall not be lawful for the state to acquire any portion of such land as it within the ceiling limit applicable to him under any law for the time being in force. Okay, so it says for this particular cultivable land, personal cultivable land, if government state acquires this land, it has to pay compensation. So this is an important point of this article 31A. Article number 31B, it talks about one particular schedule, and which is Schedule 9. And it says that no rules and regulations or acts which are placed under Schedule 9 of Indian Constitution can be challenged for the violation of fundamental rights. So any rules or regulations or acts which are placed under Schedule 9 of Indian Constitution, they cannot be challenged for the violation of fundamental rights. And if 31A, if you compare it with 31B, 31B, it is protecting these acts or regulations from all the fundamental rights, who are there in Part 3, while 31A, it saves only from right to equality, that is article number 14, and right to freedom, that is article number 19. But in a landmark judgment in 2007, Supreme Court has now declared that even the Schedule 9 rules and regulation or acts, they are open for judicial review. And those regulations which have been placed after 1973, that is the Keshwanand case, Keshwanand Bharti case, where judicial review came out to be as one of the major basic structure of the Constitution. So judicial review is a part of the Constitution, and none of the acts or regulations which are there in the Constitution can protect itself from the judicial review. So it talks about the Schedule 9, 31B, and it saves all the rules and regulations placed in Schedule 9 from the violation of fundamental right. Just for your information's sake, initially under the Schedule 9 there were only 13 acts, but now they have drastically increased to 282. Now presently we have 282 acts, rules and regulations under Schedule 9. Now moving to 31C, this talks about the laws which will be made by the state to implement certain socialist principles of directive principle state policies under Articles 39 B and C, which we will study once we'll study the directive principle of state policy. Those cannot be challenged for the violation of fundamental rights of Article 14 and 19 again. That is right to equality and right to freedom. So if state is making any law to give effect to those directive principles which are there in Article 39 B and C, those cannot be challenged for the violation of fundamental rights under Article 14 and 19. And if you can open page number 86 of PM Bakshi, the fourth para of this particular article, if you read, which are under bracket, and no law containing a declaration that is this giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy. So what it is saying is such laws which will be implemented cannot be challenged in the court. And this particular provision, it was declared unconstitutional by the court in Keshwanand Bharti case. That it will not be challenged because court said judicial review is a part of basic structure of the Constitution and it cannot be gone away with. In 1976, we again see 42nd Constitutional Amendment Act, which actually extended the scope of this particular article, and which said if state is going to implement any of the directive principles, earlier it was only 39 B and C, if state is going to implement these directive principles, it will not be the violation. But this particular Constitution Amendment Act 42nd 1976, it extended the scope of this particular article, and it said any directive principle, if it will be implemented, it cannot be considered as a violation of fundamental rights. Again, this was held unconstitutional by the court in Minerva Mills case, 1980. Okay, so this is about the controversy of these articles 31C. This we will see in more detail. We will discuss it in more detail when we are going to study fundamental rights versus directive principles state policy. And there has been a fight between judiciary and the Parliament, because Parliament, there are directives and directive principles which ask government to make certain laws for the weaker sessions or for the poorer sessions. But if they are in violation with the fundamental rights, because fundamental rights are justifiable in nature, so that is how we will discuss in a separate part, which is the fundamental rights versus directive principle of state policy. Let's move to the next article, which is article number 32, and it is the most important article of the whole Constitution, which is giving us the power to move to the court in case of the violation of fundamental right, and that in itself is a fundamental right to get the fundamental right. So let us read the article number 32, page number 86 again, which is right to constitutional remedies. Article 32 says, remedies for enforcement of rights conferred by this part. Part 1. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. Okay, so right to move to the Supreme Court for the violation of fundamental rights, it in itself is guaranteed by the Constitution. So first part, it is to move to the Supreme Court for the enforcement of fundamental rights. Part 2, it says Supreme Court shall have power to issue directions or order of writs, including writs in nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. So it says Supreme Court to issue writs, different writs, which we'll study for the enforcement of the fundamental rights. Part 3, if we see, without prejudice to the powers conferred on the Supreme Court by clause 1 and 2, Parliament may by law empower any other court to exercise within its local limits of jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. It's giving power to the Parliament. It is empowering Parliament to enable any court or to empower any court to issue directions of writs. But presently under Article 32, Supreme Court can issue writs, and Article 226, High Courts can issue writs. Part 4, if we read, the right guaranteed by this article shall not be suspended except as otherwise provided for by this constitution. So this particular right can be suspended as provided in this constitution, and this constitution, it says Article 359, President can, when declare national emergency, this particular right to move to the Supreme Court for the enforcement of the fundamental rights gets void. Okay, or gets suspended. Article 359, President can suspend this particular right. Now, as we have talked about both Supreme Court and High Courts, they can issue writs. Let us discuss the writ issuing power of Supreme Court and High Court, and let us compare them. So, Supreme Court and High Court. First thing which is very evident is Supreme Court can issue these writs throughout the territory of India. Throughout the territory of India, because it is an all India court. While High Court can issue these writs against a person or a government authority only under its jurisdiction. Only for its jurisdiction. Second difference, if we can see, is Supreme Court can issue these writs only for the enforcement of fundamental rights. Only for the enforcement of fundamental rights. While High Court can issue these writs for fundamental rights and for other objectives as well. Also for other objectives. This particular right, Article number 32, right to constitutional remedies, it is in itself is a fundamental right. So it becomes mandatory for the Supreme Court to use the power of writs for the enforcement of fundamental rights of people. So this becomes mandatory. While for High Courts, this becomes discretionary. Okay, so these are the difference between the writ issuing power of Supreme Court and writ issuing power of High Court. Let's talk about these different type of writs, what we have studied in part 2 of article number 32. There are habeas corpus, mandamus, prohibition, quo warranto, certiorari. First one is habeas corpus. Corpus is a Latin word which means body. You must be knowing it. Habeas corpus. So it literally means to have body of. So higher court, okay, or for example Supreme Court is asking the person, okay, or this can be issued both against the state and the private individuals. If a person has been illegally detained, so in that case the higher court will ask the person or the government people to produce that person in front of court, to get the body of that person and present it in front of court. And it is against both state and private. Okay. Second is mandamus. It means we command. And this is actually when the higher court gives or issue orders to the public official and asking him to perform his official duties that he has failed or refused to perform. So, orders to perform duty, and it can be issued only to government or judicial bodies. Number third is prohibition, which means to forbid. In this, higher court is asking lower court if it finds lower court exceeding its jurisdiction. Okay, so it is prohibiting the lower court to exceed its jurisdiction. So this, if we say, this talks about the inactivity of the people, while here it is prohibiting the more activeness of the lower courts. The fourth is certiorari, which means to be informed or to be certified. It is asking, higher court is asking the lower court to transfer the pending cases to it. Okay, transfer of pending cases. Fourth one is quo warranto, which means by what authority of warrant, and it is issued by the court to inquire into the legality of the claims of a person to a public office. So it prevents the illegal holding of a public office by a person. So quo warranto, by what authority? So we have already completed this in mnemonics also, how to remember these words and all. Let's go to the article number 33, which says power of parliament. So note the word here, parliament. It is not state legislature. This particular power has been confirmed on Parliament of Union of India. So power of parliament to modify the rights conferred in this part in their application to forces, etc. So Parliament may by law determine to what extent of the rights conferred by this part shall in their application to. For these many peoples, Parliament has the power to restrict or abrogate the fundamental rights. First, the members of the armed forces, the members of the forces charged with the maintenance of public order, persons employed in any bureau or other organizations established by the state for purposes of intelligence or counterintelligence. Fourth, persons employed in or in connection with the telecommunication system set up for the purposes of any force, bureau, or organizations referred to in clause A to C be restricted or abrogated so as to ensure the proper discharge of their duties and the maintenance of discipline among them. So Parliament has a power by law, they can restrict or modify rights of the people holding sensitive positions. This is article number 33. Article number 34, it is giving again giving power to the parliament to indemnify persons. Okay, so suppose if in one area there has been martial law, or martial law, it means military rule has been in place in a particular area of the country. So parliament has the power to indemnify people who actually been involved in the violation of fundamental rights of the people. So this what article 34 again giving power to the parliament. Let's read article number 35 on the same page. Legislation to give effect to the provision of this part. So it is telling us that only Parliament can make laws for the enforcement of the fundamental rights. Let's read it. Parliament shall have, and the legislature of a state shall not have, power to make laws with respect to any of the matters under clause 3 of article 16. Clause 3 of Article 32, Article 33 and Article 34 may be provided for by law made by Parliament for prescribing punishments for those acts which are declared offences under this part. Okay, so it is giving the power to the Parliament to enforce, to make laws for the enforcement of certain fundamental rights and not to the state legislatures, so that we'll have uniformity throughout the country. So this is all about fundamental rights. There is a homework for you now. After going through these fundamental rights, we want you to write 100 words, 100-word answer on the shortcomings. What you think are the shortcomings in fundamental rights? Shortcomings in fundamental rights, or in other words, the criticism of fundamental right. Criticisms of fundamental right. Don't copy from any book. Just go through these articles one by one and think from yourself. Be original in your answer. What do you think are the shortcomings in fundamental rights? Okay, because mug up questions or the mug up answers in UPSC doesn't help. You will get very average marks if you write in mains the mugged up answers from different notes of the coaching institutes. But they want certain originality in your thoughts. Okay, so this is a homework for you. You can just type it, or you can just write it, then scan it to us. 100 words this answer you write, then we'll give our feedback on those answers. So 100 words. So this is a homework for you for the fundamental rights. So here we finish a very important part and the biggest part I would say for the constitution, which is the fundamental rights, and next time we are going to finish with the directive principle of state policy, fundamental duties, and also the president. Starting of president, we'll see how president is elected, and that I would say is a complicated part of the whole of the constitution, the most difficult part, the election of president, but we have made it very easy to understand. So we'll see that in next lecture. Thanks for tuning in.